Welcome everyone to today's webinar on employment trends, what to watch and how to adjust, presented by Harder, Seacrest, and Emery. Many thanks to our presenters, Jeff and Amy, for being with us today and all the participants who have joined in. Please note this webinar is being recorded to share what we learn with the business community. Jeff and Amy will share their presentation with you, then follow with ample time for questions and discussion. Please use the chat to submit any questions during the presentation. And just a reminder, when others are speaking, keep your audio on mute to minimize background noise. With that said, I'll turn things over to Amy and Jeff.
Good morning, everyone. My name's Amy Hemingway, and we have Jeff Calabrese here as well. Thank you for joining us this morning. We have a couple housekeeping matters. As Candace mentioned, you can submit questions via the chat feature throughout the presentation. We'll do our best to answer the questions that come through today. And if we can't, then we'll try to follow up after the presentation and make sure we get answers to the questions that are submitted. Before we begin, it's important to know that our discussion today is intended to provide a brief overview of the law and best practices, as well as general tips for compliance. Our discussion's not legal advice. It's not intended to be a substitute for legal advice. If you are seeking a legal opinion, we'd be happy to talk with you outside of this webinar, or you can reach out to your regular employment counsel. So today's agenda, what we would like to cover are New York State paid sick leave, which is a non-COVID related leave. Many of you are probably still dealing with the New York State paid COVID sick leave, and this will be a different type of leave that employers will have to implement going forward. The intersectionality and discrimination claims, we'll touch briefly on that. We'll be going through some government updates, things that are happening at the NLRB, DOL, EEOC, even though we've been in this pandemic for several months, and it looks like we'll continue to be in it for several more. Other non-COVID related, non-pandemic related employment measures are being implemented, changes are being made, so we want to make sure you're aware of those. And then we will talk about some of the ongoing COVID fallout that we see our clients having to deal with and that you should be thinking about as well. So we'll kick things off by talking about New York State paid sick leave. And when you joined us today, we were hoping we'd have the benefit of specific guidance from the DOL. The DOL started rolling out guidance and FAQs earlier this week, but they haven't provided the answers or clarity that we were hoping to have on many of the issues that we'll be talking about today, such as carryover, how to count employees for purposes of determining how much leave an employer has to provide, and then leave-related documentation. Those are things that aren't really answered by the FAQ or the guidance. The DOL also has not issued any proposed regulations, and we don't have a good sense of timing for when that might occur, although we do think it will occur at some point in the future. So as a result, when we talk about New York State paid sick leave today, there will be some unknowns, and in those instances, we'll talk about what we think the regulations and the future guidance is likely to say, how we think the DOL will be interpreting things. This is, again, an issue we'll all need to keep an eye on. So even though we don't have the benefit of full guidance and regulations, there are still a lot of things that you all can be doing as employers to start preparing for your policies, your implementation of this leave, and we'll walk through those things today. So when are employees entitled to use paid sick leave? So if we can, yep, there you go. Thanks, Jeff. So the New York State paid sick leave statute allows employees to use leave within two broad categories. First, they can use it for medical reasons, and second, they can use it for what I like to call safe leave related reasons. And we'll walk through each of those two categories in more detail today. As we do so, you'll see that in some cases, the reason for leave under this New York State paid sick leave may also trigger eligibility for other types of leave, like New York State disability, the federal Family Medical Leave Act leave, possibly New York State paid family leave. So as an employer, it's important for you to think about what leaves may apply when employees are out And if you're looking to limit the total amount of time off that employees can use, you want to make sure that your policies, your practices to require employees to use leave concurrently when that's allowed under the different statutes. And if you don't put that into writing, you may find yourself in a situation where you have to stack the leaves. And so someone might be using PFL, and then they're using FMLA, and then they're using their New York State paid sick leave, and it just creates a much longer period of time when the employee can be out. So you want to make sure that where you can, you are requiring employees to use leave concurrently, which will compress the total amount of time that someone might be out. Now, I mentioned there were two reasons to use leave, the first being the medical reasons. And employees can use paid sick leave if they have a medical or physical illness, injury, or health condition that's either their own condition or that of a family member. For purposes of using this leave, a diagnosis or medical care are not required, right? So if we think about the typical sick day that an employee takes, they call in, maybe they have a fever, they're not feeling well, they have the sniffles, but they don't go to the doctor. They're just using a paid day, maybe a personal day that they've had available in the past. That would now qualify as a sick day under this New York State paid sick leave law. They also can use the medical leave to get a diagnosis, care, or treatment, or for preventative care. So when we think about preventative care, right, that could include things like the employee or the employee's child's annual physical appointment, an eye doctor appointment, a dentist appointment. So things that wouldn't qualify necessarily for any other type of statutory leave. That won't qualify for PFL or Family Medical Leave Act, but it would certainly qualify under this New York State paid sick leave law. And over the last several months, right, many employers have had to shift their thinking. They're encouraging employees now to stay home if they're feeling under the weather. In some instances, employers are allowing them to use PTO or other vacation time that they might not have been able to use in the past, right? Maybe an employer didn't have traditional sick days, but employees were allowed to use some of that PTO or vacation time pre-pandemic, or they're now allowing employees to take unpaid time without a penalty because of this COVID situation. Well, once that pandemic ends, once this new sick leave entitlement kicks in many instances, employees will now need to be paid when they take sick or safe time. And the employer will need to make sure that they are not counting those absences against employees because this leave is job protected. So that's another important thing to keep in mind. So we talked about the medical reasons for use, and now I want to turn to the safe, what I call the safe reasons for use. So if the employee or their family member has been the victim of domestic violence, sexual offense, stalking, or human trafficking, they can use this leave for a number of different reasons, which are listed here on the slide. So it could be obtaining services from a shelter or a rape crisis center. If you are trying to participate in some type of activity that's going to help with safety, whether it's relocation, enrolling kids in school, things like that, meeting with attorneys or participating in court proceedings, filing complaints, going to the police station to file a report, something like that. Those types of actions are considered safe reasons under the law, and an employee would be able to use their paid sick time to deal with those types of things. Now, these safety-related reasons for leave are something that many employers likely haven't offered before. They haven't dealt with it previously. So this will be a new area for employers, something they'll need to think about carefully. Under the New York State Human Rights Law, victim of domestic violence is a protected status. So this is a leave that also touches on a protected status. So employers will want to be careful with any information that they may get related to safe uses for the leave here, because they could be getting information that someone is in a protected status, and we'll want to treat that information accordingly. Now, another thing to remember is the safe related leave is intended to benefit victims. So if you have an employee who's been accused of engaging in domestic violence or stalking or a sexual offense, they are not entitled to use the paid sick leave to cover an absence if they have to go to court or something like that. So just keep that in mind. All right, so we talked about why you can use leave. How much leave do employees get in a year? Well, it's going to depend on the size of the employer. If you are an employer that has less than four or fewer employees and your net income is less than $1 million in the prior tax year, you still have to provide the leave. You have to provide up to 40 hours of leave, but you don't have to pay for the time. So they're, very small employers with very small income amounts will not have to pay for that leave, although they will have to provide it. If you have 4 or fewer employees and a net income of more than $1 million in the prior tax year, or you have between 5 and 99 employees, then you have to pay for 40 hours of leave. If you have 100 or more employees, then that number goes up to 56 hours. So this entitlement here represents how much leave an employee can use in a calendar year. This is the maximum number of hours that you are required to provide. Employers can choose to provide additional sick leave beyond the employee's entitlement. So if you decide as an employer that you're going to just give all employees 100 hours of PTO that they can use for sick leave or vacation or personal time or whatever reason, and you don't have any issue with them using all of it for sick leave, that's fine. You can make that choice. I would just caution that this sick leave is job protected, right? So you may, if you are providing additional time beyond the entitlement, beyond the 40 or 56 hours, depending on your size, you may want to consider capping the amount of time that is job protected and saying, listen, we're going to let you use your PTO for whatever, but only the first 40 hours are going to be job protected. And then leave entitlement is measured based on a calendar year, and that can be the traditional calendar year from January to December, or it could be some other predetermined set period. So you could use employees' anniversary dates. If you have a fiscal year that doesn't match the calendar year, you could use the employer's fiscal year. So there is some flexibility with determining that calendar year that you're going to measure the entitlement and use in. Okay, so how is leave accrued? Well, as the statute is written, an employee's entitlement may be more or less than their accrual, depending on how many hours the employee actually works. So the FAQ guidance that came out at the beginning of this week, and again, it's scant guidance, it doesn't have a lot of information in it, but it has some. That guidance suggests that an employer can cap the annual accrual at the statutory maximum eligibility for use. So if someone's eligible to use 40 or 56 hours, you could cap their accrual at 40 or 56 hours. So if we have an employee, for example, that's working a full-time schedule of 2,080 hours per year, they theoretically could accrue 70 hours over the course of the year using this 1 hour for every 30 hours worked, which is our accrual rate, the minimum accrual rate under the law. So they could accrue up to 70 hours, but the employer could say, we're going to cap it at 56. After you've, accrued 56 hours, or maybe 40 if you're a smaller employer, you're not going to accrue anymore. And that would be okay under the guidance that we have to date. Again, as I mentioned before, we do recommend that employers, consider capping that accrual amount. And one of the reasons is that will avoid any question about whether the employee is able to carry over the excess accrued time. So if with that employee who works a full-time schedule and could potentially accrue 70 hours, but they can only use 56, let's say, they would have 14 hours that they accrued in a calendar year but didn't use. Does that amount have to be carried over, right? And if we just cap the accrual at 56, there's no excess time. We don't have to worry about carryover if they've used their full 56. Now, some employers may wish to avoid this whole idea of having to track the accruing hours. And, you know, they don't want to deal with figuring out how much someone's accrued based on this 1 hour per 30 hours worked. And they instead would prefer to grant the full entitlement up front at the outset of each calendar year. And the statute allows this. That's acceptable. There's no issue with it. But employers should know that if you provide that full amount up front and an employee works less than anticipated, you can't revoke or reduce the amount of leave. So let's say we expect someone to work full-time status. We give them, 40 hours because we're an employer that's between 5 and 99 employees. But then the employee winds up being out on leave for a big chunk of time in the middle of the year. And if we looked at the amount of hours they've worked, they wouldn't have accrued the full 40. Well, we can't take it back. Once we've given it, we can't take it back. Now, in addition to not being able to take it back, the guidance that we have to date also indicates that if an employer front loads an amount based on what they think an employee will work, and it's less than the full 40 or 56 hours, let's say we have a part-time employee and based on their schedule, we think they'll only accrue 30 hours. So we give them 30 hours up front at the start of the year. The guidance says that employers still have to track the hours worked, and if the employee winds up working more than anticipated and would have accrued more than that 30 hours, the employer is going to have to true up the accrual at some point later in the year. So let's say I get to a point where I've worked enough hours that I would have accrued 35 hours of paid sick leave. The employer is going to have to give me an additional 5 hours to use. So just keep that in mind as well. And the other thing to be aware of is that there is no probationary or waiting period. The accrual starts immediately upon commencement of employment without any waiting period, without any probationary period, and use starts as soon as the employee has accrued the first hour of time. So if someone has 1 hour and that's what they want to use, they are entitled to use that. So I've mentioned carryover a couple of times. This is one of the biggest areas of ambiguity in the statute. It's silent on whether an employer can cap the amount that's carried over from year to year. It does say employers have to carry over unused time. It just doesn't say if you can cap it. And the guidance and FAQs that are currently available don't provide much clarification on this issue. So it begs the question then, does an employer only need to carry over the amount an employee would be entitled to use the following year, so meaning 40 or 56 hours, depending on their size, or do they have to allow any accrued time to carry over regardless of the amount, meaning that an employee's bank, over the course of several years could really start to add up and be more than that 40 or 56 hours, depending on how much time they've used. Well, New York City has a similar statute, a similar paid sick leave statute, and it's been in place for a couple of years now. They've issued extensive guidance on it. And if we look at that, just for some insight, right? New York State may still decide to do something a little bit different, but looking at the New York City guidance for some insight, that New York City allows employers to cap the amount carried over based on the amount an employee is eligible to use. So if the maximum hours an employee can use is 56 in a particular year, the employer can cap that carryover amount to 56 hours. So if I have 56 hours in my bank, I didn't use any this year, we get to the first of the year, I'd be entitled to carry over that 56 so that I have it available to use at the beginning of the year. That's the theory behind the carryover, that an employee will have the time available and not have to wait to accrue it throughout the course of the year. Now, the New York City guidance also allows employers to avoid the carryover issue altogether if they front the full amount of the leave at the beginning of each calendar year. So New York State guidance doesn't go into a lot of detail. We're not really sure what they're going to do, but based on what we have seen, it seems like New York State may actually go the opposite way from how New York City interprets the statute. There's some language that suggests employers may be required to allow an uncapped carryover. Again, it's not clear. So at this point, what we recommend is waiting until closer to the end of the year to finalize a policy, if that's something that you can do, if there's no immediate need to get it out. And waiting will allow you to see if there's any additional guidance or regulations that are put out. And if not, then at a minimum, employers should allow carryover for up to the amount of leave an employee would be entitled to use, right? That 40 or 56 hours. That's a minimum. And they may want to consider doing an uncapped carryover and just putting caps on the use amounts each year. So this lack of clarity on carryover is really important for employers that are considering combining their paid sick time into another PTO policy, right? So we're going to give you a larger lump sum and let you use it for vacation, regular personal time, whatever it might be. There you may need to think about putting caps in as well. And caps are important. Again, I mentioned earlier, this is job protected leave. So if you're allowing employees to use whatever bank they have for paid sick time without a cap, that results in a situation where an employer may have less flexibility to address attendance issues or make changes to address an employee's frequent absence. So, if I have 100 hours to use and I can use it for any of these paid sick reasons without any limit, we don't foresee a situation where the employer can pick and choose which parts of that leave are job protected and which aren't, unless they say up front in a written policy, only the first 56 hours, only the first 40 hours will be considered job protected. After that, you can use it, but it's not going to be job protected leave anymore. So that's important to think about. When we're administering the leave, one of the things that employers need to be aware of is that the statute says you can't require disclosure of confidential information about the reason for the leave. So you can't ask about the specific illness or injury, the health condition, what the domestic violence or safe related reason for the leave is. And we don't have guidance right now that interprets that language from the statute. We don't know how strictly the DOL will look at that non-disclosure language and what it will do in terms of enforcement. Now, guidance and sample forms that relate to the New York City paid sick leave, which is that similar statute, indicate that employers can ask for verification that the leave is for a covered reason, but that verification is limited to a statement that the employee took leave for one of the enumerated reasons in the statute without actually specifying which reason it was. So it's very broad. Yes, I took leave, and yes, it was for one of the reasons. It also remains to be seen how doctor's notes will be treated. So a lot of times employers will say, hey, if you're out for more than X number of days, before you can come back to work, you have to give us a doctor's note justifying your absence. Well, with this non-disclosure language, it wouldn't be surprising if the DOL limits when you can ask for these notes and what you can ask for in them. What we think will happen based on the New York City guidance and sort of the intent of this new New York State statute is that employers won't be allowed to ask for doctor's notes unless the individual is out for at least 3 days. And then they'll be further limited to confirming that the employee was out for a qualifying reason and then the duration of the leave that's needed or used, right? So very limited information is likely to be allowed to be asked for. Okay, so I mentioned a couple times that there are situations where employers may want to roll this paid sick leave into their existing PTO or vacation policies or other paid time off policies. The statute says that employers don't have to provide the additional sick leave if they already have existing policies that satisfy the accrual, use, and carryover requirements for paid sick leave. So we've talked with a lot of employers about how they're going to implement this new paid sick leave requirement. And I think we have yet to see one that has a policy that meets all of the requirements for paid sick leave. So even if they have a policy, they're providing the required number of hours of time off. Let's say they have a PTO policy that says if you have 4 years of employment, you get 4 weeks of paid time off, right? It would meet the hours requirement, the 56 hours or 40 hours are covered, but it's not meeting the use, accrual, or carryover requirements. And so we'll talk in a few more slides about what employers need to think about if they're planning to tailor their existing policies to cover paid sick leave. But before we do that, I just wanted to touch quickly on collective bargaining agreements. Many employers have a union in place. If you do, the statute allows you to negotiate with a union for comparable benefits, but the guidance and regulations we haven't really defined what comparable benefits include, except that they must include paid days off. If you have a current agreement that's entered into before September 30th of 2020, that agreement is grandfathered until it expires, but you will need to be prepared to negotiate when it expires and comes up for renewal. And you need to be careful about just allowing union employees to enjoy this benefit in advance of negotiating the parameters. You don't want to get into a situation where the union is claiming a past practice or trying to enforce a practice that you've put in place, thinking that you would have the opportunity to negotiate it once the agreement came up for renewal. The other thing that's important, if you have a union and you have a collective bargaining agreement and you are negotiating for something other than what the statute specifically requires, the agreement has to include an acknowledgement of this new labor law section 196 and the fact that the parties have negotiated for a comparable benefit. So that needs to be in the collective bargaining agreement. So I promised that we would talk about creating your own policy. What are some pointers? We think all employers are going to need to do some work with their existing policies to bring them into compliance. The first step is really looking at your existing policies, figuring out who they apply to, how much time is afforded, how is the time accrued or awarded, and what carryover provisions are in place. Those are the key elements that you'll need to satisfy to meet the paid sick leave requirements. And employers also need to understand what the time can and cannot be used for, right? So how do those policies meet or fall short of the statutory requirements for paid sick leave? Are you prorating benefits for part-time employees? Are you not providing them at all, right? In that instance, you may have to make adjustments because all employees are entitled to this New York State paid sick leave, not just full-time, not just permanent employees, but temporary, seasonal, part-time workers are all entitled to it. You may need to look at whether you have caps or no caps. Do you need to put caps in place? Do you need to change the existing caps to ensure that you're allowing the right amount of accrual, use, and carryover? You may question, do we combine or not combine this into a single policy? That's something that really will be employer specific and may depend on what your current policies look like and whether you have enough leave there to pull together into a single policy. And then a lot of handbooks or policies concerning attendance will have provisions talking about documentation when someone is out and what kind of documentation they need to provide to support leave. There may need to be some adjustments there because, again, the statute has some limits on what you can and can't ask for. So you'll want to make sure that your policies are consistent with that. Some other policies that you may need to think about looking at are your probationary period policies, right? This leave kicks in regardless of any probationary period. So if you have something that says employees don't earn benefits until after 90 days of employment, you'll need to amend that to say something like, unless required by statute or otherwise provided, in this handbook. Employment categories I touched on, again, a lot of times we'll see part-time employees are not eligible for benefits. Well, they are eligible for this benefit, so you'll want to tweak your language there. Discipline, you can't retaliate against or discriminate against an employee who's used this leave So if you have a policy that disciplines for attendance on a kind of no-fault point system, that may need some adjustment to reflect this statute. And then you'll want to double check your termination policy. Under the law, you don't have to pay out the accrued unused time. You'll want to check your policy to make sure that if you are paying out accrued unused time, maybe there's a cap on it, so you're not running into a giant bank of time because you've allowed uncapped carryover. So that's something you'll want to look at too. Record keeping, I'll touch on real quickly. Under the law, employers need to be able to provide a summary of accrued and used time within 3 days of a request by an employee. And that includes time that was accrued and used in the current calendar year, as well as of the time for any prior calendar years. So you want to keep those records. The New York Labor Law, Section 195, says that employers must notify their employees of their sick leave policy in writing. So this New York State paid sick leave law doesn't specifically say that employers have to create a policy, but that does appear somewhere else in the labor law. So employers should be thinking about how they want to notify employees of these new sick leave requirements and how they plan to administer them. And then the law says you have to keep records of the accrual and use for a minimum of 6 years. That's consistent with other labor law record keeping requirements. We would recommend keeping them for 7 years. The reason for that is if someone comes in on the last day of the 6-year statute of limitations period and files a claim and you destroy your records at 6 years, you're going to have a tough time defending that claim because you don't have any records. So if you keep them a little bit past the statutory requirement, you're going to have those records available in the event of a last minute claim and put yourself in a better position to defend. Okay, so between now and January 1st, which is when employees will be able to start using leave, what do you need to do? You need to start tracking your accruals so that you can determine the minimum amount of accrued leave for January 1st. If you are using a system where you're just going to front the leave, this accrual may not be as critical to you, but you should at least be aware of it. You want to make sure you're confirming that your systems have the capabilities to track accruals and use as well. Think about what your policy is going to look like. Start to think about what requests for leave approval forms might look like. It's likely the Department of Labor will issue some kind of template for that. So, you might want to think about what it should look like, but also be prepared to just, jump on those DOL templates if they come out. Make sure you're revising your policies as needed. And then you want to communicate with your employees and train your supervisors. A lot of employers rely on their managers as the point of contact for call-offs or absences, right? Make sure you notify your supervisor that you're not going to be in. Well, it's going to be important to provide training on what those supervisors should and should not say and what types of documentation and information they can ask for and what they should not ask for. Again, there's that non-disclosure language in the statute, which seems to suggest that the information an employer can get is very limited. And we also know that those safe-related reasons may touch on someone's protected status. So you want to be careful about how you are getting information to support use of the New York State paid sick and safe leave. And then, as mentioned earlier in the presentation, the statute states employers can't inquire into the detailed reasons for the leave. So it's really important that personnel understand how to get the information they need to apply the leave without over asking, right? So there's a fine line there, and we'll just need to make sure employees, managers and supervisors in particular, are prepared to handle requests for that type of leave. So we're going to turn from New York paid sick leave to our next topic, which is intersectionality in discrimination.
Looks like you're frozen there, Amy.
Yep, looks like Amy is frozen. Maybe give her one more. No, she's back.
I'm back. Okay, sorry,
Oh,
my
you're back.
computer went haywire. I think it got unplugged. So intersectionality is a term that we've been seeing used more frequently of late, but it's not a new term. It's a concept that's been around for a while. And it refers to complex discrimination claims that involve a combination of two or more protected statuses. So it's most commonly been seen in the context of a sex plus claim, meaning someone's claiming discrimination based on sex plus some other protected status. But use of this term is expanding and becoming more common with race-based claims as well. To help you understand intersectionality, I will share a personal anecdote to me. So I'm a female. I've always appeared young for my age, particularly when I was early in my career. So on two different occasions, once when I was this freshly minted attorney right out of law school, and once a couple of years ago when I was nearly 20 years into my career, I went to traffic court to help out clients and some friends with traffic tickets, right? So when an attorney goes to traffic court, they get the benefit of sitting in the front row of the courtroom, right? They don't have to sit in the gen pop, they get to sit in the front row. Well, the first time I went into court and tried to take my place with the other attorneys, first the court clerk, then the bailiff, and then finally the judge, all questioned whether I was actually an attorney. So on the second occasion, here we are nearly 20 years later, I go into traffic court, I go to sit down, and a fellow attorney sitting in the row leans over and says, "This row is reserved for the attorneys." So both times I'm dressed in a suit, I'm carrying a red weld, I look professional. I don't think I look any different than anyone else sitting in that row. But all of the individuals who questioned me were older males. So in my mind, this begs the question, am I being questioned about my right to be here because I'm a female, because I look young, or is there some intersection, some combination of these two statuses that makes people ask this question? Why are you here? Or they don't think I belong there. When intersectionality claims arise in discrimination cases, courts approach it in one of two ways. So most often, courts have looked at and analyzed the two protected statuses separately. So there might be discrimination as to one status, for example, sex, but not the other, for example, race or age. Less frequently, courts have analyzed the claim taking the two statuses together. So truly looking at whether, for example, older females were treated differently than any other class of individuals, or whether Black females were treated differently than all other females, males, or non-Blacks. When these issues arise in a discrimination case in a court, the treatment by the court, whether they're looking at these separately or combining them together, can have an impact on which burden of proof applies in that case. So if we're thinking about a sex plus an age example, sex discrimination claims are handled under Title VII. Age discrimination claims arise under the ADEA. They're two separate statutes. Title VII uses a pretext or mixed motive analysis, whereas the ADEA uses a because of or but for analysis. It's a harder standard to meet. If a court were to look at these separately, they might find that the Title VII standard is met, but the more stringent ADEA standard is not met. So they might find, yes, there's sex discrimination, but no, there's not age discrimination. A court that looks at it as an intersectional claim, one that's combined, and this happened recently with the 10th Circuit, what the 10th Circuit did was looked at the claim and said, we're going to treat this under Title VII as a sex plus claim, and we do find that older females were treated differently than everyone else. Males and younger females were treated like all males, but the older female population was treated differently, right? So they there applied a Title VII standard which was a lower standard for that age discrimination part of the claim, right? So it's just something that could result in some uncertainty as to how claims will be treated, what standards of proof might apply as intersectionality becomes more common in the courts. So what does this mean for employers? Well, when you're looking at the impact of policies or changes in processes, it's important to think beyond the obvious groups and instead also consider how the impact applies to subgroups that might have combined protected statuses. So minority males, minority females, older minorities, younger minorities, any different combination of things. So I do a fair amount of work with affirmative action and diversity analyses, and this is something that I've seen the federal agencies in particular start to target in audits. They don't just want to see how males versus females or minorities versus non-minorities fare. They're looking at these smaller subgroups and may even drill down to specific racial groups. You know, how are Hispanic females faring compared to everyone else? How are older Black males faring compared to everyone else? So they really are drilling down. If you're conducting something like a pay analysis, or you're looking at recruiting and hiring patterns or personnel decisions, what can you do? Just manipulate the data in different ways. When you do that, try to avoid creating a situation where you might create a document that you'll have to turn over in the event it shows something unfavorable, right? So consult with an attorney before you start to do some of these analyses, so you might at least have a chance to claim attorney-client privilege. So with that, I'm going to turn things over to Jeff to talk about the government updates.
Thank you very much, Amy. And that's the first time I'd ever heard that story from you. And I'm sorry that happened, obviously. But that's certainly a good example of, or kind of brings to life, the concept of the intersectionality that you just talked about. So appreciate that story. And, you know, the sick leave law obviously is really a sea change for New York employers. And it's a big topic right now for all of our clients, trying to understand how those new laws and now waiting for detailed regulations can be applied. So if you have follow-up questions, there was a lot of material, but if you have follow-up questions on it, obviously don't hesitate to give Amy or myself a call. We can help you work through that. You know, people down in New York City that have offices down there have had a paid sick leave law and safe time law in effect for some time, as Amy pointed out, and they've grown accustomed to it. So we certainly will in New York, the rest of New York as well. And frankly, I wouldn't be surprised if at some point we've got a national law that provides very similar provisions, and we will be that much further ahead. So I want to talk a little bit about, I'll give you some quick hits. I've got a short little time here left, but I want to give you some quick hits on some things we're seeing in the last few months on some of the legislation that was enacted associated with the pandemic. Obviously, it was chaotic for human resource professionals and business owners back in March and April, with a lot of new laws that were coming in. And we had to urgently try to determine what those laws provided and how we were going to apply them. Well, now we've had more time, obviously 7 months into the pandemic or so. We've got court decisions, we have further guidance, we have interpretive regulations that have come down that give us a lot more to lean on. So I want to try to highlight some of those. So the first thing is updated guidance on the Families First Coronavirus Response Act. So as you know, this came into effect in early April, and it sunsets at the end of December. It provides for paid, in essence, similar to FMLA, certain type of paid leave for circumstances that are related to the pandemic. So for example, if you are diagnosed with COVID-19, or you are seeking treatment or seeking a diagnosis for COVID-19, or you have a family member that has been diagnosed, or a school is closed for one of your children, which causes you to need to be home with that child. These are all various items that can qualify an employee for the paid leave under the FFCRA. Now, there was a court decision over the summer from downstate, a federal court, that found that certain provisions in the original law were unconstitutional or improper. And the Department of Labor has since updated the law to make clear that, first of all, leave under FFCRA may be taken only if work is available. So if the employer shuts down and remote work is not possible, an employee who falls under one of the characteristics, for example, if they're diagnosed, cannot claim the leave. It's only if they would otherwise be at work, but for their qualifying characteristic. The second thing is that employees may not take intermittent leave without the employer's permission. There was some question on that under the statute, and the DOL has made clear that leave for a child's closing of a school. So right now, a lot of schools are in the hybrid situation where they go to school a couple days a week in person, and then the other 3 days they're at home. And if the children are young enough, that may cause the parent to need to be there for them while they're at home. That is not intermittent leave. That actually is each event, each school closing, each day the school is closed is a qualifying event under the statute. So that has been made clear under the Department of Labor guidance. The DOL has made clear that employees should submit leave documentation ASAP to the extent it relates to school closings, for example. That should be done in advance. But obviously, if it's a diagnosis or something that came upon urgently, then it should be done as soon as possible after that. And then there was a healthcare worker exception that was in the statute that provides that employers do not need to provide FFCRA leave to healthcare providers, but it was ambiguous in the original statute, and the DOL has now made clear as a result of this court decision that this applies only to employees within the healthcare organization that are providing direct patient services. So HR staff, for example, or other back office type employees that are not integrally involved with the patient care would be entitled to the FFCRA leave, even though the employer itself is a healthcare organization. The second thing, so we talk a lot about the COVID and a lot of the rules that have come in and guidance we're now getting, but life still goes on in the non-COVID world. So we did receive an opinion letter from the DOL at the end of August, and it addressed the fluctuating work week. I won't get too deep into this just because of the time, but if you are familiar with this particular method of compensating employees, and in short, you pay the employee a set salary for their work each week, irregardless of how many hours they work that week. And as long as they're making at least the minimum wage and you pay them half time for the hours they work over 40, that is a basis for, that's proper basis for pay. There was some ambiguity in the regulations, but the DOL has now clarified it through this opinion letter that the fluctuating work week method can be used even if the hours fluctuate, or I should say if they do not fluctuate above and below 40. So they can fluctuate from 34 to 38 to 32 to 36 and at no time go above 40 hours, and that is still an eligible basis for paying the employee under the regulation. So that's some clarification that we've never had. Now, these are related to the pandemic. So the Department of Labor issued a field bulletin, I think it was at the end of September, maybe a little bit earlier. In any event, the question now with a lot of employers having employees at home, teleworking, obviously it's become a premium on trying to figure out when those employees are working. So what we've learned from the DOL field bulletin is to make clear, which I think you probably could have assumed, but to make clear that employers need to come up with a process and make sure that that process is communicated to employees as to how they are supposed to report their time. And there is more flexibility given now that employees are working at home. So it used to be if you were working at home and you started your day at noon, for example, and the last time you worked was 6:30, the DOL would assume, absent very clear evidence, that you worked from noon until 6:30 and you needed to pay that employee all the way through. In light of the pandemic, the DOL has issued guidance and also this field bulletin to make clear, look, some employees can work 9 to 11, and then their child might come home from either daycare or from school, and they can take time off from 11 to 1 and deal with the children, do lunch, do whatever it is, and then return to work at 1 and work till 4. So as long as you have a process in place for accounting for those hours, that can be broken up throughout the day, and the assumption or presumption is not that the employee had worked all the way continuously throughout the day. The other thing is, if you have actual or constructive knowledge of unscheduled hours, so for example, the employee puts on their timesheet every day, I work 9 to 5, but yet you know that from 9 p.m. until 11, the employee was sending emails or submitting work product. If you had reason to know that, the employer has an obligation to make sure that that time is put on the timesheet. So it always rests on the employer to confirm the number of hours that have been worked. And if employees are working beyond their normally scheduled hours, and you know it, either actually or constructively, obviously that time has to be paid. That being said, if the employer doesn't, the employee doesn't properly keep track of their hours, the employer only has to take reasonable measures to figure out what those hours are. They don't have to go through impractical steps of digesting the email network and really jumping through hoops to try to figure it out. There is some obligation on employees. But anyway, it just emphasizes the need to make sure with people working at home, you're still following what you would normally do in your workplace, which might include punching the clock or logging into a computer network to indicate when you're working. EEOC has also issued some guidance with respect to teleworking. The few main points that we take away from this guidance are, first of all, if an employee has been diagnosed with COVID or is taking care of a family member who has been diagnosed with COVID and is thus authorized not to come into work, but you are able to obtain telework out of them because of the nature of their job, you still have to remember that that's a medical condition. It's still confidential information. So you cannot say to other workers, well, Joe is working at home because he got a diagnosis yesterday of COVID. That is protected health information that an employer still has to remember to maintain the confidentiality of. The other thing that's been questioned, and I've had a lot of questions on this from clients, but early on in the pandemic, people were working at home, right? Everything shut down. And everybody was trying to make do, with the exception of essential workers, working from home. And people got used to that, and a lot of people like it. And now that employers are asking employees to return to work, some employees are saying, look, I feel more comfortable at home, or I'm more productive at home, or I just plain would like to stay home rather than driving however far I have to drive to get to the office. And the question becomes, well, does the employer have to grant that? And the initial answer is no. An employer is allowed to stop the required telework, when the pandemic has eased, and to demand that employees come back to work, because the employer is allowed to decide we want a in-person workforce. We don't have to, just because we've been able to live with it before, we don't have to grant every employee that going forward. That being said, it does not eliminate your obligation that if someone is entitled to an accommodation because of a disability, you still have to go through that ADA analysis under New York human rights law to determine whether telework is a reasonable accommodation. Now, what the EEOC has made clear is that the employer's ability to live with it now during this pandemic may be a factor in demonstrating whether that telework is a reasonable accommodation and would not cause undue hardship on the employer going forward if the person has a disability that would justify that. But all things being equal, and if there's no disability, again, just because you've been able to live with the telework doesn't mean you have to continue to do it when the pandemic subsides. You still have the right to bring that employee back. The only other question it becomes is a morale issue. A lot of employers obviously now are very understanding. My firm, frankly, has been very understanding of letting people, if they want to stay home, they can stay. I don't see any recent time or imminent time that we're going to change that. And it's a morale issue. You just want people to be comfortable, and as long as they're productive and they're completing their responsibilities, then we are totally fine with that. And a lot of employers may feel the same way. We did get a decision on handbooks out of an NLRB administrative law judge in early September. It's a Stericycle case, just highlights a couple of things. And perhaps some of the folks on the line don't necessarily have unions in their shop. And the thing we have to remember is that these types of decisions are applicable to non-union employers as well. So the National Labor Relations Act is not something you can turn off just because you know that you don't have a union at your workforce or representing your workforce. This applies to all employers in the United States. And one of the things you've probably read and seen over the years recently is this emphasis on policies and whether they are overreaching. So employees always have the right to engage in what's called concerted protected activity for mutual aid and protection. So one employee can say to another employee, hey, how much do you earn? And what do you do for your job, and what type of duties? Because I'm making the following, and I really think it's unfair that you're being paid more or being paid less than me, and maybe we should talk to the employer about that. That is a protected conversation. And an employer could not say to one of those employees, hey, you're supposed to keep your pay confidential, and you shouldn't be talking to each other about terms and conditions of employment. That's private. You should keep it to yourself. And let's say the employer decided to terminate one of those individuals, that employer would find themselves subject to an NLRB charge for unfair labor practice, even though they are not a union workforce. So 2 things that we take from this decision, emphasize number 1, your confidentiality policies relating to investigations. So first, you cannot say to an employee that they must maintain discussions about the harassment allegation and the investigation confidential to the extent practicable. That is overbroad. Employees are allowed to talk between and amongst themselves about situations that affect their terms and conditions of employment. What you can do, though, is put in your policy that the employer, so the business, will maintain the confidentiality of the harassment allegations and the investigation to the extent practicable. And the reason that's allowed is we don't want employees to think, we don't want to chill their rights. We don't want to stop them or dissuade them from complaining about conduct that's wrong in the workplace. So it's okay that you let them know that you're going to maintain confidentiality to the extent practicable. The other thing that we need to know is it's okay to prohibit under your policies disparaging statements made to third parties. But again, you can't prohibit the 2 employees from talking among themselves and criticizing a supervisor, or criticizing the pay structure, or criticizing the benefits. That would be an illegal policy. All right, so last section, and it may leak over for 5 minutes here, but I think some of this stuff is important, so hopefully you'll be able to stick with us. We've got all these laws. So the FFCRA sunsets at the end of December. We're reading a lot in the papers about unemployment benefits and whether or not there's going to be another stimulus that is going to, in some fashion, supplement the state unemployment benefits. We've got a lot going on as the year progresses here. We also have the overlay of the election, right? And depending on how the White House election turns out, and depending on how the Senate turns out, can dictate where things are going to go. Obviously, if Vice President Biden wins the election and the Senate flips to the Democrats, then you can expect as we get into 2021, there's going to be a lot more employee-friendly laws that are probably going to be passed, and it's going to take some time, but the administrative agencies like the EEOC, the NLRB, they will all start to flip over to democratically appointed directors and staff that will start to put more employee-friendly provisions in place. Obviously, the flip side is if President Trump retains the White House and Republicans retain the Senate, then it's probably going to be pretty status quo. But if the White House goes Republican or Democrat and the Senate goes Republican or Democrat, and you've got more of a logjam, that also may lead to some status quo. So there's a lot on tap for employment law as we go forward here with this election in just under 2 weeks. As you approach the year end, there's a few things to think about. The child care time off requests are obviously going to continue with school. A lot of schools are already talking about whether they're going to return to a remote environment because they're concerned about a second wave of the coronavirus. And then when you combine it with the flu season, we are going to run a situation where it's been kind of calm in New York the last month or 2, but we're starting to hear rumors, not rumors, but just concerns about whether we're going to get back into more of a lockdown phase again. So I think you have to start to prepare yourself for that and be worried about it. Requests for teleworking, same thing. And as I already mentioned with the EEOC guidance, you have to do an individual analysis on each of those and decide whether it's for a qualified reason or whether it's just an employee who prefers to do it. And then again, what you either are obligated to do or what you want to do as a good employer to maintain morale. There may be some workforce adjustments you need to worry about. Obviously the economy is uncertain. Hopefully we pull through this and things continue to grow economically for everybody. But, we had a lot of layoffs for various companies, furloughs, and companies are going to have to make those hard decisions, whether some of those furloughs are either extended or turned into permanent layoffs, or whether new layoffs need to be made. Those implicate things like WARN, how benefits might be accelerated, if you're terminating part of the 401k plan. All these various things come up. So you have to start thinking about those well in advance. And if you're an HR professional and your owner comes to you and says, we need to lay off 25 people next week, Monday, the first thing you say is we need more time because we have a lot to analyze because the risk of liability is significant under WARN and some other statutes. And then I guess lastly is the year-end bonus, year-end reviews and raises and bonuses. Obviously you have to think about what have we gone through the last 7 months and what type of considerations are we going to give to our team because they had to deal with a lot just like we have. People had to figure out how to work from home, figure out how to manage family members wandering around the house while they're trying to focus on their work. And, are we understanding of the difficult circumstances that we all went through and how is that going to impact your review? How is it going to impact raises? Did they meet performance metrics or did their failure to meet performance metrics, was that really caused by outside items, the pandemic or clients or customers or whatever the case may be, and how do we factor that in? And then of course bonuses, what economic situation is the company in? We want to try to maintain morale. If we can't afford bonuses, is it a situation where you're going to indicate, look, no bonuses this year, sorry? Or are you going to say, we're going to delay the bonus to mid-year, we're going to give you a bonus, but we're going to build it out over time. So a quarter of it per quarter you'll be paid. Or if you can't do it economically in terms of money or whatever the case may be, do you give them some non-monetary benefits such as some additional time off or something that will reward them for their dedication and their service during this difficult time, but also something that you can sustain, notwithstanding the difficult situation that we're all in. So, okay, so that's the last of my items. Hope that was helpful. Let's see if we have any, find the chat feature or the Q&A. I don't see anything in the chat. So it looks like we don't have any questions. I'll let Amy give the last word, but for myself, thank you very much for the opportunity. I appreciate Sheldon and Candace and the rest of the folks at the Chamber for giving us this great opportunity to present to you. And if anything that we had to say, piques your interest or gives you cause for concern or raises an issue that you want to just talk about further, just give us a buzz. We'd be happy to vet it with you. Amy?
I think Jeff wrapped it up very well there. And all I would add is, again, thank you for your time today. And we hope it's been helpful. Thanks, everybody.
Thank you.
Thanks, Amy and Jeff. This was a great presentation.
You're welcome.